The Supreme Court takes a case on majority black districts. Do we still need the Voting Rights Act? A New York bill bans anonymous tips about child abuse. Will it do more harm than good? And a states' rights battle over abortion pills. Stay tuned, Ivory Tower is next.
This program is brought to you by the members of WCNY. Thank you.
Good evening. Welcome to Ivory Tower. I'm David Chanatry from Utica University. I'm joined this week by Nina Moore from Colgate University, Anirban Acharya from Moyne College, Sarah Pralle from Syracuse University, and Rick Fenner from Utica University. When part of the Voting Rights Act was ruled unconstitutional 12 years ago, Chief Justice John Roberts wrote, "Section 2 of the Act is permanent, but maybe not for much longer. The court is deciding whether Louisiana used racial gerrymandering, last year when it created a majority black congressional district. The outcome could impact other majority black districts around the country." So Nina, what is at stake in this case?
Well, what's at stake is whether states can purposefully engage in race-based districting. The original 1965 Voting Rights Act was about preventing the deprivation of individual rights, but then there was a 1982 amendment to that act which allowed individual groups to come and make a claim of vote dilution, and that is about group rights. The issue here is that the Louisiana state legislature, under court order, was not only engaged in race-based districting, but also trying to preserve Republican control, because even though the state is roughly 30% black, only 1 out of the 6 seats were a majority black district. So I think what it's going to come down to is some things we've seen the court sort of talk about in a side way, and that is whether you can give constitutional rights to groups, and groups that are based on race, because the Constitution really talks about individual rights. The other thing is what Roberts has consistently referred to as racial stereotyping, when folks assume that black folks will vote based on certain black interests. And so the court will, I think, tackle that head on, and I think it will continue to permit lawsuits that are brought to prevent intentional discrimination, but the requirement to put in place majority black districts, I think that's going to go the way of the wind.
So racial gerrymandering is not allowed, but political gerrymandering is, and in some cases, aren't they kind of hopelessly intertwined?
They are hopelessly intertwined, but to your first point, race-based gerrymandering has been allowed because the way that Congress changed Section 2 of the 1965 Act is it said that a claim can be made not only with regard to intent, but also impact being dilution. So you can, in fact, challenge if you are bringing a cause for a black group and say that you don't have sufficient representation of blacks as a group.
But hasn't Clarence Thomas said that there is a conflict between Section 2 of the Voting Rights Act and the Equal Protection Clause? So that certainly seems which side he's going to fall on. But I agree with you. I mean, how is it in our best interest to allow, this gerrymandering for political purposes to protect incumbents? Why is that the best way to decide, how we're going to get our representation?
Because the court said it is, right? I mean, that's the court took that on, several years ago in another case, if I recall correctly, right? And they said that's okay.
That's okay,
but so, Sarah?
Well, I was struck in the oral arguments by their sort of obsession among some justices that there has to be sort of a time limit to these protections, that there has to be some sort of sunset. The Voting Rights Act was designed to enforce the 14th and 15th Amendments. Those are constitutional rights. I'm not sure why we expect that has to suddenly disappear. I was in my classes this year, I've been teaching about freedom rides, freedom summer. This was only 60 years ago that people risked their lives in order to get the 1965's Voting Rights Act. And I think the justices are either willfully naive or, just don't understand the potential consequences of this, in the sense that I think states can find very creative ways to bring back some of these restrictions on voting, subtle creative ways to try to deprive people of the right to vote, in part because they do want to secure one-party rule in the South. And so I don't understand this idea that we're not going to go backwards as a result. There's this obsession they have with kind of ending this, and I don't really understand that.
Yeah, could I just respond to something that Rick said about the reading of the act? Where we see Thomas going here is in closing the door, because previously all of the other decisions rendered by the court were interpreting the Voting Rights Act as, having to do with congressional intent. But what it looks like is going to happen here is they're going to find the act in violation of the Constitution. And so in that case, Congress cannot come back and effect a legislative reversal of it as it has done in the past, because only the court gets to interpret the Constitution.
Okay, now, Anirban, go ahead.
No, I think it's very interesting because in 2023, when the Allen versus Milligan case, I think, when the Supreme Court actually came down against Alabama's redistricting plans, and Kavanaugh and Roberts joined the liberal justices, and after that, Louisiana changed to create this one extra seat in Shreveport, and of course this group of self-proclaimed non-African Americans, as they call themselves, they started this case with the Louisiana, and yes, I think the conflict is whether the Section 2 of Civil Rights Act violate the 14th Amendment of the Constitution. But in this case, though, in 1981, there is a Thornburg case. There is a 3-point formula that the Supreme Court had said that in order to comply with the VRA. But we will see that whether, what the Supreme Court thinks at this moment, that whether stemming or stopping racial discrimination in voting also violates the Equal Protection Clause or not. And to that count, I just want to give out some statistics, right? In 1950s, I think there were only like 6 black representatives from the South. Now we have 29. And if this goes through, partisan-wise, the Republicans stand to add something between 12 and 19 seats, which will basically erode any Democratic support in the South.
The South was basically, from Reconstruction, the end of Reconstruction, until 1965, was essentially a one-party system, although it was a Democratic party.
Right.
So, I mean, is there a risk that if the Voting Rights Act is gutted, essentially, that we would go back to a one-party system, basically?
Well, I'm not sure if it'll be a one-party system because of the racial makeup, but what I will say about the issue in this case is that there are 60 black representatives in Congress presently, but only 15 come from majority black districts. So the U.S. Deputy Solicitor General used those numbers to make the case that you don't need to do this intentionally, that it happens.
I would argue, I argue this gerrymandering cases across the country are aimed at monopoly power.
Yes, absolutely. Secure Republican majorities.
Yes.
Governor Hochul has until the end of the year to sign a bill that would reject anonymous reports of child abuse. The bill was written to reduce false and vindictive tips. In New York City, less than 7% of anonymous reports of child abuse were confirmed. The Office of Children and Family Services opposes the bill, afraid it will deter legitimate tips and place children in harm's way. So, Anirban, what should the governor do? Should she sign this bill?
So I'll just throw out some statistics that I learned from the articles you sent me, that about only 7% of all the calls that were made were anonymous, and of those 7% calls, 96% were not valid, right? So given that statistics, I am flummoxed, right? There's 2 sides to it, right? One, if you actually stop the anonymity, maybe some legitimate cases people would not call right? And then we will have a situation where a child is being unnecessarily harmed. But the history shows that it's not about reporting, it's actually about following up all the important cases that we kind of see of child abuse. It's about the following up on those cases that created, that lack of following up that created the problem for the child. But I can take a different tact, right? Well, we are mandatory reporters for Title IX. When a student comes and tells us, we tell them that, look, this thing will remain confidential, but I cannot remain anonymous. I have to report it to the Title IX coordinator, and we will protect you. It's our main job is to protect you. I don't know why we cannot have something like that. And in this case also there is a felony charge if you falsely report. So I think confidentiality route is okay. Title IX, it works. I don't see why it shouldn't work here.
Yes, I think the governor should sign it for that very reason. It does not eliminate confidentiality. That if I call in, they'll take information on me so that they can, if it turns out that I continue to make false statements or that I'm doing this, to harass someone, that they can enforce the law. But my name isn't made public, isn't given to the person that I'm accusing. ProPublica did a great job on, looking at a number of cases where, families are facing visits every month because someone is calling in, clearly harassing. They never find any evidence, but they feel, the protective services feels the need to go through. And what about the damage to the child? There was a woman who had faced 24 of these where they come in the middle of the night and they interrogate the child. And so I think the governor should sign the bill because it walks that fine line between encouraging people, giving people the confidence to call in, knowing that their name won't be made public, but still getting information on as many cases.
And the bill did pass with broad bipartisan support.
Yeah, I'm not opposed to the bill, but I do think about the roughly 735 kids who would be left out. That is, of the 150,000, of those, I think it's 735 that actually have substantiated reports anonymously. So my thought is some additional precaution should be taken. It was a person who wrote into the Post-Standard and said exceptions should be made for family members and for neighbors. But something that the Post-Standard editorial board said I think is important also, and that is that the public has to be educated about the difference between confidentiality and anonymity, because otherwise you're going to have the opposite problem of folks being really afraid to actually do the reporting.
That seems like that's a real issue there, that people won't want to call in because they don't want to, they're afraid of what might happen to them.
But only 7% are anonymous. People are willing to call and provide information. It's a fairly small number. Of the 150,000 calls, only 10,000 of them are anonymous.
Yeah, but because the bar is low now, right? But you raise the specter of potentially being exposed, and that number could go up significantly.
But I think if you educate people about what confidentiality means and the protections of that, I think you're probably going to have those people being willing to give their names. I mean, if it's a serious charge. And so I think part of it is a lack of education about what that actually means, confidentiality. And I also think that, we need to have the ability to change laws that are not working. And it seems like there's broad bipartisan support, as you mentioned, but also among professionals, child advocates. It's bipartisan. A lot of lawyers, people are weighing in on the side of changing this law. And to me, that suggests that there is something actually wrong, right? And we can't just have laws that have negative effects that outweigh the benefits and not do anything about them and just leave them on the books because we don't want to change things.
Okay,
I think
and when you say changing the law, what you really mean is passing this new law.
Well, passing this new law, but
right.
which changes the old
Banning the
policies, right?
anonymous.
Which is, we need to have the ability to evaluate policies and readjust based
Plus,
on
there's a
evidence.
cost to going and investigating all of these claims.
Sure.
Because, if you have so many that are unsubstantiated, then that takes away resources from really going and investigating the cases that are truly child abuse.
Yeah, but again, that's 735 of substantiated cases, those matter.
My math was a little different. I had 420,
You're the
but that's still
economist.
420.
Yeah,
and I
it's-
understand
yeah.
that that's
All right,
real
you were
cases.
trying to jump in on this?
No, I was saying that the critics are pointing out that there should be sufficient guardrails to protect siblings, victims of domestic violence, and close neighbors from retaliation. So that might be something that we can think on when they are doing this legislation, that what are certain guardrails that are necessary for really vulnerable populations that really fear for their life. And they don't want to, they want to remain anonymous as a result.
But how do you do that?
That's fair, very fair
you
question.
You can't say,
no.
I am the sister of, therefore I should be anonymous.
Right.
Because
Yeah.
to prove you are an exception, you have to be providing information. So
It's difficult, definitely.
All right, now a states' rights battle is brewing over abortion pills. New York and several other states have passed shield laws protecting health workers who prescribe and mail the pills to patients in states where abortion is against the law. Texas has sued a New York doctor saying New York's law violates the Constitution. State Attorney General Letitia James is defending the shield law. So, Rick, don't states have to recognize the laws of other states?
Yes, while I might be sympathetic to the fact that Texas is not allowing women in that state to have access to the abortion pills, for New York doctors to be sending them to Texas, well, let's turn this around. Texas law puts no restriction on the number of rounds a gun magazine can hold. New York doesn't allow magazines that hold more than 10 rounds. What if Texas gun shops start mailing these magazines to New Yorkers? Wouldn't we complain? Wouldn't we think that that was violating, our laws? I think so. I think we need to be consistent in this. So I'm not in agreement with the shield laws as they're being discussed here in New York.
Yeah, I mean, you're talking about guns, but if we look at California, I mean, how often do we buy stuff that has except in California, right? So here are the exceptions to things that cannot be shipped to California: plants and animals, certain foods and fruits, automotive parts and accessories, styrofoam, high flow shower heads and non-compliant generators, whatever that is. New York also has a list, and so why not, in the case of where something as important as abortion is concerned? And I think just generally the whole idea of states' rights ideology in the past used to be for those who were against change and progressive moves, but now it's becoming a refuge for left-leaning states, not only in regard to abortion, but also immigration, environmental policies, healthcare policies, DEI policies. And so we need to think about this very carefully.
So, Sarah, there is a full faith and credit clause in the Constitution. That's used to say that we in New York have to recognize those laws in Texas and elsewhere?
Yeah, I mean, I do think if this comes before the Supreme Court, they're probably going to find that it's unconstitutional, our shield laws. On the other hand, I understand the push behind them. I understand the desire to help women safely get abortions and have full reproductive rights. And, the larger context of this is that when the Dobbs decision was a big victory, certainly for the pro-life movement legally, but practically speaking, not a lot changed on the ground. In other words, the number of abortions in America has actually gone up slightly since the Dobbs decision. And I think what this suggests is something bigger, which is, there's two ways to try to reduce abortion. You can make it less necessary or less available, right? And the anti-abortion movement has really privileged this kind of less availability, right? Try to criminalize it. These are very harsh penalties that they're trying to inflict, not on providers, for example. It's probably going to cut to the women themselves at some point. Thinking that that's the way to reduce abortion. I think this is an opportunity for them to rethink that strategy. If they're really interested in lowering abortion, there's much better ways to do it. The best one, of course, is to make contraception more available and cheap, and that's the ACA, the Affordable Care Act, requires that health insurance companies cover contraception. That's something the Republicans are trying to defund, those subsidies. So their efforts are actually going to lead to more abortions in this country. So I'd like to see the pro-life movement get more serious about ways to actually tackle what they see as a problem.
Anirban?
Yeah, I mean, I want to refer to this interesting case called VL versus EL in 2016. And here the Supreme Court answered that does the full faith and credit clause of the Constitution require that an Alabama state court recognize the Georgia state court's adoption order? And unanimously the court said yes. So if I interpolate that here, it will be said, does the New York state courts have to recognize the court order from Texas? Seems like it should be yes, right? So we will see what happens with this. And the idea is clear that a state may only refuse to afford full faith and credit to another state's judgment if that court did not have subject matter jurisdiction or jurisdiction over relevant parties. Here the court has subject matter jurisdiction, right? So I do think at the end of the day, this will end up in Supreme Court, and the Supreme Court might weigh in, as it weighed in VL versus EL, in favor of Texas.
Okay, I know you're dying to get in on this.
Well, I mean, listen, this is going to sound harsh, but the recourse for women who live in red states that are against abortion is to leave those states. Exit voice and loyalty. Go someplace else where your rights are protected.
But a lot of them don't have that ability, and that's hugely
Well, a lot of them
disruptive
do.
to
For those
people's
who do, and then that
lives.
just increases the power of the pro-abortion states because you've got more population and you have more representation as well.
So, I mean, it seems like the states are sort of amping up in their very different approaches into this. But of course, there's another issue too, which is using the Comstock Act, right, to outlaw, or I guess it'll be determined, but doesn't that outlaw mailing these pills anyway?
Right.
could, yeah.
The California has this law that, right, they want to mail in without any name, with complete anonymity.
Yes.
And that can run afoul these different laws. But, Nina, I want to slightly disagree. I mean, we are situated people, right? We live out, we are,
Yeah.
so it's difficult for people to just pen their lives and just leave. And so, I mean,
And our
it's
rights
a very difficult
shouldn't be
decision.
contingent on.
But that's
That
where we
doesn't-
are.
Yeah,
We are
that's,
there.
yes.
We
and-
definitely
Okay,
are
and
there.
where we are right now is time to go to A's and F's. So we're going to go to F's. Nina, with yours.
Okay, my F goes to Secretary of War Pete Hegseth and the new rules for journalists who are based in the Pentagon. The rules implicitly threaten reporters with punishment if they ask Pentagon sources for information that source is not explicitly authorized to discuss. The rules are of a piece with President Trump's statement that, quote, he finds the press to be very disruptive in terms of world peace and maybe security for our nation, end quote. I find the rules contrary to everything that is in the First Amendment. That is first for a reason.
Anirban.
My F goes to the leaders of the young Republican groups throughout the country who have been fostering a culture of racism, including anti-Semitism and support for fascism among their group conversations. Most of the messages are too vile and bigoted to utter in a show like this, but can be succinctly summed up by one of the comments by a young Republican leader, which says, I quote, I love Hitler. I encourage our viewers to go and look at the expose by Politico.
Sarah.
The EPA this summer canceled a $20 million grant that was intended to protect an Alaska Native village as part of their attack on so-called DEI programs. It was supposed to protect it from flooding, and just this week the village flooded and its key infrastructure is increasingly at risk because permafrost is melting beneath it. But the administration is not just depriving of native Alaska villages of help, it's also denying federal disaster relief to communities across the country. So in that sense, I guess they're equal opportunity when it comes to not helping America citizens.
Rick.
My F goes to the Big Ten for considering to sell a 10% stake in its sports media and sponsorship deals to a private equity group associated with the University of California pension system. The proposed deal is another example that college football and basketball are nothing more than professional sports leagues and, in my estimation, should not be afforded tax-exempt status. It also shows that despite billions of dollars of revenue, college athletics isn't profitable for even schools in the Big Ten.
A's. Nina.
Yes, my 8 goes to the more than 100 news organizations and journalists that rejected the new Pentagon rules. They turned in their press passes and signed a statement saying that the policy is without precedent and threatens core journalistic protections. More impressive is that they did this in solidarity with not only the New York Times, Washington Post, and NPR joining in, but also conservative news outlets like Fox News and Newsmax. Kudos to all of them.
Anirban.
My A goes to Bend the Arc Jewish Action's endorsement of the NYC mayoral candidate Zohran Mamdani, thus demonstrating the long tradition of Jewish action to stand for justice and against repression. They wrote, on Rosh Hashanah, many of us had meals with loved ones and neighbors we sometimes disagree with, but we share core Jewish values of love, justice, and a better world for all future generations.
Sarah.
My A goes to Brown University, who this week rejected a White House proposal of a so-called compact, which would have required them to submit to certain conditions in order to continue to receive federal funding. Earlier this summer, they had negotiated with the Trump administration and agreed to various policy changes. So it's very important that they are defying them now. And it reminds us that bullies will not stop bullying until you stand up to them.
Rick.
Piggybacking on my A was going to MIT, Brown, UP, and USC for declining to sign Trump's so-called compact for academic excellence in higher education. 5 other colleges have been offered the deal, hopeful that Vanderbilt, Dartmouth, University of Texas at Austin, University of Arizona, and the University of Virginia will also see that they shouldn't be selling their academic freedom. It's not in the best interest of their institutions, higher education, or the country.
Okay, real quickly, and your A's and F's about that Pentagon policy, not only First Amendment, but just holding them accountable is very important.
Absolutely.
Thank you for joining us this evening. For comments, you can write to the address on your screen. If you'd like to view the show again, you can watch it online at WCNY.org. I'm David Chanatry, and for all of us, have a good night.
This program is brought to you by the members of WCNY. Thank you.